All right, so I think Dina and I are your first session of today, but we are going to be presenting the reality of Pro Bono, a case study. And so we have you for the next hour. We hope that you'll learn about why you should do Pro Bono, how to do it well, and how to begin and end Pro Bono representation. And I'm Asia Brooks. Sorry, I probably should have introduced myself at the beginning. I'm the Pro Bono Coordinator for New Mexico Legal Aid's Volunteer Attorney Program.
Good afternoon. I'm Dina Afek. I'm the Director of the Volunteer Attorney Program with New Mexico Legal Aid, and I'm happy to do this session. Several of you already are doing Pro Bono, so this should just be sort of a reinforcer. And for those of you who have not tried it yet, there are lots of opportunities. So we get started with a little role play.
Fun. This is fun. We get started with the most fun part of our CLE, I think. Do you want to turn your chair that way?
No.
Can they still see us? Oh, okay. Okay.
Right.
Good morning. My name is Asia Brooks. I'm the lawyer who's going to be speaking to you about your legal issue today. Thank you for coming to the legal clinic.
Oh, okay. Asia?
Yes.
Yeah. My name is PB Pro Bono Barbara, but I go by PB. Okay.
PB.
Please call
Nice
me
to
PB.
meet you, PB.
Okay, and I'm here. This is the first time I'm a little worried about it because I need to go to court tomorrow. My landlord is kicking me out tomorrow at 8:30. I hope you can be there and help me out because I have no idea what to do.
Okay. Well, can I look at your document there?
Sure.
Let me see what you
Where
got
is it?
there. I think it's that right there.
Okay, here
There we
we
go.
go.
Let's see here. So this document says that you were served with this almost 30 days ago. And you're telling me you're just now trying to take care of this right before your court date?
30 days ago? No, I don't.
That's what this says. It says that you were personally served with this 30 days ago. So I'm really not sure what we can do at this point, but let me look at this, okay?
I did try to get help, and I like somebody from the, what is it called, like volunteer attorney program, told me to call back, but then my phone was disconnected, and I couldn't
Your
get a
phone
hold
was
of anyone.
disconnected?
Yeah, like we didn't have money to pay, so they disconnected it.
Well, it seems I think I'm seeing a pattern here. It sounds like not paying your debts is becoming a trend with you.
Oh, maybe you don't want to help me.
Well,
maybe
no,
I'll
have a
just
seat.
leave.
Let's look at some of your documents. But just so you know, if you don't pay your phone bill, your phone's going to get turned off. If you don't pay your rent, your landlord's going to try and kick you out. So it looks like this is about eviction and your landlord trying to kick you out of your home.
Yeah, my landlord trying to kick me out, and Jamie was sick, and we had to go to the hospital, and then we don't have insurance, so we had to pay everything out of pocket, and like there was just no way.
Well, Pro Bono Barbara, PB, sorry. A normal person would have a savings account. So when you have emergencies like this, then you have money to keep a roof over. I'm just trying to help you learn these things so that in the future you don't have these same problems, okay?
I don't think you really want to help
So
me.
I think a savings account would actually really help in future situations.
A saving account? Like I don't have any money, like anywhere. Well, like, I don't have a savings account. The little money we get, we're putting in an envelope under the mattress.
Yeah. Well, that's really not helpful, but let's look at your paperwork, okay? Let me see your paperwork
More
again.
paperwork?
Let me look at this. Now, this is saying that the landlord is saying that you owe more than just your last month's rent. This says that you haven't paid since January. That's what your landlord's saying.
Every month I go to the office, I give them an envelope with my payment.
How long have you lived in that house?
6 months.
And you've always paid your rent on time?
This month was the first month that we couldn't pay because Jamie was in the hospital, I told you.
Okay. Well, do you have some sort of proof that you paid?
Proof? Well, he knows I was there. I was at the office.
Well, do you have something written from your landlord that said that you paid?
No.
Do you pay well, obviously you don't pay your rent by by credit card or by check, since you keep all your money under your mattress and you don't have a bank account. But now, so you didn't get a receipt from your landlord that said, hey, this is how much this person
No,
paid me?
I asked him at the very beginning, I asked him if he could give me a receipt, and he said yes, he would, and then he never did.
And you didn't do anything, once you didn't get that receipt, you didn't follow up with him?
I'm
You know,
scared.
why wouldn't you have demanded those receipts from him? Because basically, at this point, you have no way to prove that you paid.
I'm so scared to be kicked out. I don't want to go back to the shelter. It's like, it's bad enough. Nothing even in the house is working. The stove is not really working well. The heater is off, and now it gets a little warmer.
Well,
I'm
I
very
am just hearing a lot of excuses here, but let's see if there's anything else we can do. The landlord is also saying that you did significant damage to the home. He's saying that the walls have holes in them, all the windows are broken, and the floors are scratched.
damage. No, that was there from the beginning. All those holes were there from the people that lived there before. And I asked him to fix it, and he said he would, and he never did.
Oh, wow. Well, why would you move into a house where the windows were broken and there were holes in the wall?
I told you, Jamie had to go to the hospital. She's very sick. And Johnny Jr. also has like bad allergies, and now they said something about him being like autistic or something like that. I have to run from appointment to appointment. I'm like, I just came out of the shelter. That was the best we could do.
Well, you know, personally, I don't know anyone who would put up with a landlord like that despite your circumstances. So let's look at your lease. It would say something about the terms of renting in that document. So let me see your lease. Do you have your lease with you?
A lease? What's a lease?
Okay, well, a lease is a written contract. A landlord and tenant both sign it before the tenant moves in, and it says what the rent will be, for how long, who will do what, all of those things.
I don't know. They may have given me something, but I don't remember signing anything. I just like talked with him.
So you just talked with him and you guys had a verbal agreement? You didn't have anything written down?
Yeah. I think there was a paper, but I don't think I had to sign it.
Okay, but you don't remember if
No.
you have that or
No,
where it
no,
is or
no.
anything like that?
No.
Okay. Well, good luck tomorrow. There's really
You're
nothing
not
that
gonna
we
come
can
with me?
There's really nothing we can do about this right now. I suggest you ask the judge for a reasonable amount of time to move out. And I hope the next time that you change some of your behavior so that this doesn't happen to you again.
I don't want to move out.
Well, I'm very sorry, but that's all that I can tell you today. I would just ask him for time to move out.
I should have known that you can't help me. Nobody ever helps me.
All right, and scene. So I think at this point, we just want to hear from the audience. Some of the things that you saw that maybe the lawyer could have done better, or some of the things that were difficult for the lawyer to deal with that happen with people who are experiencing poverty.
I think you're really mean.
Well,
She was so
I'm a
mean.
good actress, hopefully. I'm usually not that mean during our clinics, but. So what were some of the ways that I was being unfeeling or rude to her and didn't really understand where she was coming from?
Well, you talked too much and jumped to conclusions rather than eliciting the information from her. So she said one thing or two things and you immediately went to the result, which may or may not have been the whole story. So you weren't getting good information, so you can't give good advice if you don't have good information.
Right. Anyone else? See anything different? Yes, sir?
I think you were being very judgmental right from the very get-go when you indicated to her that she had a pattern, if you will, of incurring debts and was being irresponsible.
Anyone else? Yes.
understanding of why someone wouldn't have a bank account, or why, kind of like a elitist attitude of, you know, why someone wouldn't have a bank account, or, there's something else too, but along those lines.
Okay, yes. Anyone else notice any other things that were mentioned? Yes,
It
ma'am.
was like you were blaming her for her situation instead of understanding that it could happen and helping her out of the situation.
Yeah. So what were some of the things that you saw were kind of obstacles for the attorney? This young lady mentioned the bank account situation. Like, what were some of the other things that came up from the client that might have indicated that she was experiencing poverty or in poverty? Yes, ma'am.
The fact that she has a sick child or whatever, and you were strictly dealing, and maybe it's sometimes justified, or in most non-poverty cases, to focus on the eviction, but she has a whole constellation of problems, and of course, as a poverty lawyer, you should know that, which you do. But you're both great actors.
Thank you. Yes, Kayla?
I think you also didn't focus on the fact that maybe she can't read. When you asked about the lease, and she looked at you really puzzling, and then you asked about the receipt, and she looked at you like really puzzled. I mean, there's a possibility she cannot read, because I've run into people at some of the clinics that can't read, you know, and they're really embarrassed to tell you that.
Yeah, definitely. Caitlin, did you have something?
Yeah, I just think that something that we encounter a lot with clients is like the general disorganization, and they're not able to collect their information they need to bring to you to meet with you, and so that's just something you have to understand from the get-go, that it's really hard for them in general.
Yeah, definitely. Yes, sir.
Again, I think as a practical problem for you as the attorney, is the client coming to you at the 11th hour, if you will. She's got court the next day and wants you to do something for her. And I think as a practical matter, I don't think that there's really a whole lot that you can do for her. So again, that's not uncommon, I think, for not just someone in her situation, but maybe for a lot of people to just bury their head in the sand and hope it's going to go away.
Yeah.
What could the attorney have done?
I would have explored the issue of nothing working in the apartment. Because she could have used that maybe as a defense, but she could have went to court and said, well, I'm withholding the rent until this stuff gets fixed. Whether or not that was the truth, but.
Ma'am in the back? You had something?
Yeah, it's, I mean, kind of similar, just, the way your character was being with her is like telling her like, well, this is all your fault, but like, you didn't have a lease, like what's wrong with you for not remembering if you have a lease, when it's entirely possible that this landlord's trying to take advantage and there isn't a lease.
Right.
And,
Yeah, definitely. So I think we're going to watch a video at this point. We want to follow this up with some, this is actually, Dina could probably give the introduction of who Donna Beagle is, but.
So Donna Beagle is an expert on poverty. She herself grew up in poverty, and she made it her life's mission to learn and teach about what it means to live in poverty. She has written books. She has trained attorneys, judges, other folk, social service providers, and so on and so forth, all over the world, as a matter of fact. She has been here last spring, in the fall, for the Children's Law Institute. She has been here before. She will be coming here to do a day-long training with legal service providers, attorneys in August. So we have, what we want to show is one clip of some of her videos that pertain to what we're talking about today.
When I was at University of Portland, age 28, working on my bachelor's degree, I got my GED at 26. and ended up at University of Portland. I arrived there believing that the people who were making it didn't care about the people who weren't. Anybody here ever represented someone in poverty who said no one cares about people like us? That's, if you listen to youth and adults in poverty, that's one of the first things you'll hear. And poverty life experiences teach you that. I remember watching my mom and dad go into a helping organization, and there would be plastic or glass between them and the people. And I'd be thinking as a kid, why don't you talk to them face to face and like get to know our names? But nobody knows your name when you're in poverty. Your client, recipient, you just don't get a name. You're quite invisible. So watching at 7th grade, I remember telling a teacher, I don't want to go outside. They fight out there. And the teacher said, there's nothing I can do. You need to go outside. I have work to do. So I go outside. I get beat up. Handfuls of my hair falling out of my head. No one cares. So poverty, lived experiences teach you that. And the other variable that is so important to understand is that we're segregated in America. Raise your hand if you know that middle-class people spend time with middle-class people. So if you're in the war zone of poverty, who are you hanging out with? Other people who are in a similar situation, or as I say, out of salt and butter too. There's nobody to ask, what does that word mean? Nobody to ask, what else might I do? You call somebody up even just to try to get empathy. My car got towed. Me too. You know, there's nobody to call. You don't have phone numbers of anyone with a title. So you're just in this isolation where everyone is in crisis. So what I learned at University of Portland, because it was really my first time being around people who were making it, being out of the segregation of poverty, the isolation of poverty. And University of Portland's a really privileged school. It's sister to Notre Dame. So I'm around even more privileged people. And I'm watching them do caring behaviors. They are volunteering at soup kitchens, donating their time, volunteering to help people. And I'm thinking, this is not my lived experience. This is not what I knew growing up for 28 years in poverty. And so I'm puzzled by, it looks like they care. Then I'm thinking, well, if they care, why aren't they doing something? Why would you allow people to live in crisis like this in your own community? So I started talking to people about poverty, and it became so clear really quickly. And this was a pivotal moment in my life. They cared. I learned that my fellow human beings really care about the people who live in crisis of poverty. How many of you care about the people in your community who are fighting poverty on a daily basis? I have yet to ever have a helping professional raise their hand and say, I don't care. We care. We care. So Mother Teresa says that to believe your fellow human beings don't care about you is worse than hunger. And I believe that. I'm convinced of that from a personal perspective, because it was so amazingly enlightening and lifting to learn that, wow, they really care. And as I began talking to people about poverty, I learned so quickly, even though they cared, they didn't have a clue. They could no more describe my life in generational migrant labor poverty than I could describe middle-class norms, middle-class lived experiences, middle-class vocabulary. We were so segregated, our lives so very different, same species, but different contexts. So I started studying, I switched my bachelor's degree and started studying, where do people in America learn about poverty? And some people would say, well, I've lived it, I don't need to learn about it. And so I would talk to people, like when I was doing my doctoral research, I asked for candidates of people who grew up in poverty who had achieved a bachelor's degree. And this guy said, I'll do your study for you, I grew up poor. And I said, thank you so much, so tell me, how did your family get by? He said, well, my father was a physician. This actual quote. He died when I was only 12, and I had to go live with my grandparents. I worked in their store, and I pulled myself up, and I became a doctor like my dad. And I'm listening to him through the lived experience of generational poverty. through fighting my brothers for the back window of the car when cars had back windows, because that was the very best place to sleep. No feet in your face, and you could see the stars. And I'm thinking, you knew someone who owned a store? And you were related to them? That's not poverty. But you got to look at it from his paradigm. Who do the children of professionals hang out with? Other children of professionals. And what humans do is we compare ourselves to the people around us. So if you grew up with people around you who had more, highly likely you internalize you grew up in poverty. Another guy said, I'll do your study for you. I grew up with nothing. And I said, well, how did your family make it? He said, well, you know, my dad owned a restaurant, but anyone could do that. There's a little bit to that, you know. You can't just own a restaurant, you know. You got to have knowledge, skills, credit. But that's the other faulty assumption we make, is that if I did it, it's easy, therefore you ought to be able to. Because we don't understand. We don't, you know, Bush Sr. said, there's not social class in America. That's somewhere in Europe. Beg to differ. Beg to differ. It's right here. How many of you know that? I mean, you could go to any community in America, call up a real estate agent and say, where are the good schools? Which means we know what? Not everyone gets the same. So for me, this is more than work. I tell people I know too much to be quiet. Martin Luther King said if we are silent about race, we will have racism in all our systems. The same is true about poverty. So the more I studied, the more I learned the university systems were not our teachers of poverty. They were graduating people to be psychiatrists, counselors, judges, lawyers, governors, elected officials, business owners, President of the United States, and they never had Poverty 101. Show of hands in this room, how many of you have had the course History of Poverty, United States of America? And you can take a look around, because it doesn't matter if I'm speaking to doctors or teachers or superintendents. I never see a hand. We don't know our history. Who can finish this sentence? If we don't know our history, we are... And that's what you see happening.
Did it make you feel uncomfortable? Yeah?
Yeah, a little bit. I think that a lot of us don't think about the fact that there's so many people who are living in poverty. It's an overwhelming number, and so it's easier to just not think about it.
Uh-huh. Yeah.
Well, one thing it made me think about is I do believe that if you haven't experienced something, you can't possibly know exactly how that person feels about it. But I wonder, in terms of what we do, you, not as volunteers working in bits and pieces, how not having experienced that and not really ever being able to identify with being homeless, perhaps, how that affects whether or not you can be effective in how you do it. And what made me think of it was my husband is a psychologist, and he worked for 35 years at the VA with vets in PTSD treatment. And a lot of them were very upset that they wanted to work with a psychologist who had been in the armed services. And they didn't want somebody treating them who had never served in the armed services. So I wonder if that happens in this setting and how you ever get around that, because you can't experience poverty if you've never experienced it and you don't want to experience it, right?
Right. Yeah, I think that's a good point, and I think we should kind of ask her that when she gets here in August specifically. But from my perspective, and also having worked as a counselor with a lot of people with PTSD, you can learn from your clients it's not the same as having had the experience, but I don't think it's absolutely necessary to have had the experience to be able to understand and have empathy and be able to work with a population. I think that's kind of a way of like shutting people out and may have some other reasons for it. So I don't really subscribe to that. But I do think that it's important to be open and curious and learning and picking up on things, and things like what we role played before and what some of you have said of like the attorney, an attorney who is there and listens and actually, you know, is quiet and lets the client talk and
Maybe we can write some of them down.
yeah, good idea.
Okay, so let's say.
That would be very, very beneficial, and really have empathy and you know, walk in the shoe, at least in the imagination of that person. I think that's possible. So, what are we writing down?
I'm doing positive ways to
Positives.
assist, and
Okay.
then some of the, whether it be from the role play or some people mentioned some things earlier of things that we do, maybe from our middle class experience or from other things in our life that we might be negative to speaking to a client or representing a client or something like that. I think someone mentioned interrupting, which is kind of a...
Right. So, any other things, any things that stood out from the video or that made you think like, oh, that's something I do when I work with clients, or that's something I should do, or like would be great to do? Yeah.
I think one thing is, you know, I think you can never completely understand like somebody else's experience, but I think it's just important to acknowledge that, and instead of trying to be like, oh yes, I understand you, I totally get where you're coming from, instead to kind of acknowledge that you don't understand, and acknowledge the fact that you can learn, that there are things that this person knows even if they don't have fancy degrees, that there is always something that you can learn from the person in front of you.
Yep.
And also kind of understanding the difference between empathy and pity, in that she kind of touched on it with like the soup kitchens and things, and kind of like, you know, where were these people, and you know, being empathetic and trying to understand to the best of your ability, but not kind of being like, but not crossing that line into just pity and kind of looking down on them.
Yeah, I think you addressed a whole bunch of issues, but one of the things that you said about acknowledging the difference in experiences, maybe having questions rather than assumptions. Somebody else said that, you know, like it's very dangerous to have assumptions about somebody else. Yeah. What else?
I think there's different degrees of poverty also. I practiced in North Carolina for a little while, and you could see the poverty there. But sometimes some of the people at some of the clinics, they come in and they look, I won't say affluent, but they look like, well, I guess they have on maybe their best clothes. But then when you start talking to them, you understand that you know, they do have on maybe their best clothes, and their situation is totally different than what you would assume it is, you know, by the way they speak. And I always give them the read test. So, you know, I hand something, I say, can you read this to me while I'm writing down? And if they can't read, then I know they can't read. And then I always ask them to write something for me to see if they can write. I mean, it's, you know, and I don't tell them to write it, I just kind of little test. And I started doing that in North Carolina because I was surprised at how many people did not know how to read and write in North Carolina.
Yep.
I mean, it's shocking, absolutely shocking.
That's a very, very good point. And
In this state is poorer than North Carolina and Mississippi.
right. Yeah, or people are marginal about reading. They're very uncomfortable with it. I think that's
And so I figure if they can't read and write, then, you know, a lot of them are coming in to represent themselves in court, and I'm like, you know, and you know, I don't want to say, and you can't read and write. And then if I do give them advice, I have them repeat everything back to me twice. What to say to the judge, and how to say it, and how to be respectful. And we do a role model like this, and we practice. Now, whether they do it when they didn't before the judge, I don't know.
Yeah, I know, like at the Lollapaloozas, many of you have attended those. I often sit at the entrance and have people sign in. And there's also the table for right next to it for the attorneys to sign in. And it's really challenging to like not make assumptions about who is coming in. Oh, this one is an attorney and this one is a client. And I kind of like challenge myself to really be trying to be free of these assumptions, but I inevitably go oh yeah, you need to sign in over here. No, I'm here to want to see an attorney, and vice versa. So anyways.
Any other helpful and positive ways that we can assist clients, whether it be at a clinic or in like a direct representation situation? I think Kate mentioned she repeats things to the person. That's a really good technique, just so that people can, and even attorneys, like I have to repeat things to attorneys. I'm an attorney myself. I have to repeat things to myself 3 times before I actually really understand or can remember it. Mm-hmm. And even then, sometimes I can't remember it.
Rule of 3 in litigation. tell the jury it 3 times.
There you go.
And maybe they get it.
Okay.
Yes, sir.
Yeah, I would say chatting with the client, getting to know them a little bit better. A lot of times you can connect in ways that you wouldn't anticipate. Even though you may be from a completely different class, you may have some things in common. You know, you might both be New York Mets fans, whatever. But there are ways that you can connect across those barriers.
Yep. Find the common ground.
I think I just spelled that wrong, but.
Great.
So these are all very helpful ways. And I think we mentioned some of the negative ways, but somebody mentioned interrupting earlier. Someone also mentioned assumptions. Anything else? I did a whole lot of mean things to her when she was sitting there telling me her story.
Judgment was mentioned earlier, but especially like comparing them to what's normal.
Yeah.
I think that's not helpful.
And just sort of a sense of condescension.
Yes, ma'am?
I think just not a negative thing, but one of the things that I experienced in private practice, and I think it applies to interaction with any client, is when do you not to jump on your client's bandwagon, tell them what they want to hear because you feel bad for them. That's not giving advice. So it's hard. You have to ultimately tell this lady that she has to get out of her house. She has no proof of anything, and there must be there's a more tactful way to do it than the way Idris did it, but I think that's important, and you have to be careful not to, I think you have to be careful not to be blunt or accusatory, but to let them leave with the truth. You're not doing them any favors if you empathize, sympathize, commiserate, and they walk out the door with false.
I think that's absolutely crucial, and really like being giving advice and counsel or brief service in a legal fair, legal clinic of any sort is an art form, and it really truly is, and it requires a different kind of lawyering than what you're used to in your private practice when you have somebody come in, even for an initial consultation, or when you work with a client that you see again and again. It is a very specific skill set that you have to develop, and like any skill set, it's like muscles, you have to practice, because you are in a very limited time frame. You have a client that comes in with a ton of stuff from a place that you often don't know. You only hear a little piece of what of the whole story, and you have to somehow make sense of that, figure out in your head what is the best thing for that particular client in that particular moment, and give them just enough that they can retain it and do something with it, not too much and not too little, and make them feel that they're being heard. So that's a lot to do in often 20 minutes or half an hour increments.
Well, I think we got some good lists. Now we're going to try and let you know how to enhance the beneficial ways that you can help clients, and to minimize the negative ways that we impact clients. And Dina's going to give you a little bit of the history of poverty and some of the guidelines that we have to abide by.
Yeah, I'm not really talking about the history of poverty, that would be interesting. But I want to just tell you that the need for free or low-cost legal services is nothing short of a national crisis. It is an absolute abysmal state of affairs with how few people, not only in this state, all over the United States, but in particular here, because we're a very poor state, are not getting the legal needs met that they have. Civil legal needs are there, people losing their homes, people losing their children, people losing health care benefits, all kinds of things, without having any chance at access to justice or access to legal assistance. And that's where the pro bono efforts, volunteers such as you are, all come in. Over 50% of cases that get referred to legal aid, for New Mexico legal aid, for example, cannot receive representation. We know that about 70% of family law cases are, there is no attorney, they're pro se litigants. We also know that, and you'll, I'm sure, know that about a fifth of residents of New Mexico live under the national poverty line. That's yeah, like 430,000 people. We also have about 900,000 people on Medicaid, and we are ranked dead last in the child poverty rating in the country, which is really shameful. About a quarter of kids in New Mexico live in households that are below the federal poverty line. And of course, not having representation, having all these people having to represent themselves, or not getting legal help at all, or not seeking legal help, causes a lot of social ills and problems in society as a whole. It has repercussions way beyond just the legal system. You have a whole section of handouts pertaining to the reality of pro bono, and you can look at that later on. The first handout is about some little suggestions of what to look for when you're working with clients in poverty. And the second one is a chart of 2018 LSC eligibility guidelines. LSC is the Legal Services Corporation. New Mexico Legal Aid is funded in large part by Legal Service Corporation, and they tell us of who is considered poor and who is deserving of legal help from us. So for example, so we have to work with people under 125% of poverty, or with some exceptions between 125 and 200% of poverty. So when you look at the chart and look at a family size of 4, and you go all the way over to the weekly, what the weekly income is, and that's gross, mind you, not net. It's a little over $600. So, you know, if you have a family of 4, like your grocery bills will alone be about that amount per week. So can you imagine like making do for everything else, including if you have a car insurance, including rent, including food, including everything like that. This is really not I mean, this is not something that people can live off. So, and people that are making more than 200%, we can, for example, we cannot serve. So, and those people are still poor and they're still in need. So, and I don't know what the guidelines are for the clinic at the homeless shelter, if there are any, but those are, for example, ours. And every civil legal service provider has slightly different guidelines and requirements. So I'm going to turn it back over to Asia for
the pro bono rules.
Yes.
Not the most fun part of the CLE presentation, but the rules are very important too. Who knows what pro bono means? Anyone know? Yes, Judy?
Pro bono is short for pro bono, for the good of the public.
Okay. Very good. Yeah, that's basically what it means. Anybody know what does pro bono mean to them? Does it mean giving back? Anybody have any ideas? Specific to lawyers. Lawyers. Mm-hmm.
Yeah, I think lawyers have an ethical obligation, no matter what drives them into the law. I think they have an ethical obligation to give back. I think there are a lot of lawyers who don't think in those terms. People who do shareholder derivative suits and things like that. But
So I think you hit the nail on the head. I think you said something, you said give back, right? So,
owe to society by the very nature of the profession, I think.
and I think you hit the nail on the head there. So pro bono means giving back to your community, right? We have 2 pro bono rules in New Mexico. We have Rule 16601 and Rule 24108. They're both in your materials after what Dina just presented. I think it's on the 3rd page. 16601 kind of outlines what the rules are of pro bono in New Mexico. And so a lot of times people think that pro bono is just doing things for free, right? They think, oh, it's me giving legal services for free. That's what pro bono means. Not necessarily. Our rule in New Mexico is very broad, but it is very specific as to what it means. So in paragraph A, you can see that it does mean providing legal services without fee or expectation of fee to persons of limited means, right? So that's what most people think of as pro bono, giving a legal service without a fee to somebody who is of limited means. But it also includes, if you look at paragraph B, providing legal services at a substantially reduced fee to persons of limited means. So it doesn't necessarily have to be for free, but it does have to be at least at a substantially reduced fee if you're providing them to persons of limited means. Now, as Dina kind of said when she was talking about the poverty guidelines, each organization has a different level at which people of limited means are defined, and what that substantially reduced fee is defined as. So, but in general, our rule is very broad. However, What do you think about an attorney who has a client and then they don't get paid by that client? Is that pro bono? Who thinks that's pro bono? Yay. Okay, depends on what?
Depends on, is the client of limited means?
Okay.
Could the client pay the fee?
So-
And what, in what circumstance are you representing this client?
Exactly. I think that key part was in what circumstances are you representing that client, because what pro bono means is that you're not charging them at the beginning, right? You're doing it as a substantially reduced rate at the beginning. There's no expectation that you're going to pay the full fee at the beginning. So like if you have a client who you take on and you do a retainer and they have to pay this money and then they don't pay you, that's not pro bono because you expected a fee from them, right? But if you did that out of the goodness of your heart, or you did that at a substantially reduced fee from the beginning, then that is pro bono, okay? Because I have a lot of attorneys who come to me and they say, I do pro bono all day, every day. Half my clients don't ever pay me. And I say, well, did you ask them to pay you at the beginning? And they say, yeah, they were supposed to pay. And I'm like, well, I'm very sorry to tell you this, but that unfortunately is not pro bono. Even though you did, in the end, I guess, provide those services for free. Yes, ma'am.
This is probably not where you want to go, but
It's okay.
I'm so curious because I never thought about it like that.
Uh-huh.
But I'm wondering, let's say you have a family law client. That's the best example of people who don't pay, right? They start out, you get a retainer, and the case mushrooms,
Uh-huh.
maybe into abuse allegations or whatever. If you make a decision at that point to keep representing that client because circumstances have changed without getting paid rather than withdrawing from the case, is there any way those things could be?
So you started it off for a fee, you charged them a fee, you got the
Right.
money, and then they had more problems and you didn't charge them for those. Kind of.
It's related to the same problem, it's just that you thought it was this kind of divorce and it turned out to be this
A
kind
big
of
old divorce. Well, I would hope that in some of your retainer agreement wording, you would specifically say what you were going to do for that client. If you said, I'm going to do this part for you for free, right? If you said, all right, I did that other part for a fee. Now we're doing this other part and I'm doing that for free. That part would be considered pro bono. The first part that you did for a fee would not be considered pro bono, right? So I have a very limited amount of time, but our commentary has some very good wording in it about why you should do pro bono. The committee commentary to Rule 16601 says that every lawyer, regardless of professional prominence or professional workload, should aspire to provide legal services to those unable to pay, and personal involvement in the problems of the disadvantaged can be one of the most rewarding experiences in the life of a lawyer. That's why we want people to do pro bono, not just for the client's benefit, but for the lawyer's benefit as well, right? Giving back makes you feel good too, hopefully, it should. Just very briefly to go over Rule 24108, don't look at it yet. Who knows what our pro bono requirement is? Do we have a pro bono requirement? Okay, so what does the court say should be our contribution to pro bono? Anybody know?
50 hours a year?
Yes. So it is not a requirement, it's not mandatory, but in the rule it's suggested that every attorney do 50 hours of pro bono work a year. And Rule 24108 kind of lays out some of the options in how you actually do your pro bono. So they have this suggested little table here where it says if you do 0, because you can also make contributions towards pro bono, correct? And so their suggested amount is if you do 0 hours of pro bono to give $500. If you do 25 hours of pro bono, then that's cut in half. 250 is the suggested contribution. If you do all 50 hours of your pro bono service, then you can contribute at your discretion. That's suggested, okay? And you know, nobody really is gonna punish you if you don't do your pro bono. Nobody's gonna say you're a bad person. But it really does.
We are not?
We are not. We are not. We might shame you in other ways, but we're not going to shame you to your face. But yes, it's very good for the attorney. and it's also very good for the clients. So, I'm sorry?
Where does the money go?
So the money goes to a fund for all of, there's 16 pro bono committees around the state. Each judicial district has a pro bono committee. Some of the districts, because they have more than one county, have more than one pro bono committee. So there's 16 all across the state. And so if you've been to a Lollapalooza, or you've been to a legal fair or a legal clinic, those were probably done by the Volunteer Attorney Program and the pro bono committee. So those funds are gathered and they're split amongst all those committees to do pro bono services. So the Lollapaloozas, if we have to rent tables, you know, for the attorneys to sit at, that comes out of the pro bono fund, okay? So it is really helping provide services to the people if you are giving that money.
And the reason Asia's job is to, in part, to coordinate with those pro bono committees and be in touch with them and to make sure that they're actually doing some pro bono work and collaborating and coordinating with them.
One other question. On these large law corporations, does each and every attorney in that law corporation have a pro bono requirement? Well, not
Does
really
each
requirement.
attorney?
Yes, each attorney.
Yes.
Okay.
Yep.
So like the corporation just doesn't.
Right. So it should be you as an attorney wanting to give back to your community. And each person should have that inner desire, maybe to do their pro bono with the homeless legal clinic or with the volunteer attorney program. But as long as you're doing it, we are happy about that.
And I do think that you will benefit from it way beyond just the good feeling. It's like also expanding on your repertoire and on your skill set of what you can do and the population that you serve. As we've looked at before, there are certain things that are very specific to folks who live in poverty. Learning that and working with that population will add you tremendously in everything else that you do as a lawyer.
Plus you meet really interesting people and you get really great stories.
Great, yeah, for your memoir. It's a great thing for, once you write your memoirs, you will go back to all your pro bono experiences. So I'm gonna talk about conflict of interest. So any ideas how conflict of interest applies to pro bono? Is there any issue with conflict of interest when you see somebody pro bono? Do those rules apply?
I ran into one. I got assigned to one party, and another attorney got assigned to another party, and both parties were from your organization. And that no longer can happen. There was a conflict there.
Okay, you're talking about the guardianship issues. Yes, and what Kate is alluding to is that, and that's an issue for us as a civil legal service provider, that when we get the request to find a pro bono attorney for an adult guardianship, for the petitioning attorney, to find a petitioning attorney, we can do that, but we cannot at the same time also try to find somebody for a GAL. And it used to be a little bit different in the past, but that we've kind of tightened that up because of issues of conflict of interest, because we as an agency are bound by the conflict of interest rules just as much as you are in your own private practice. Now there is something else that's at play here. And that's Model Rule 6.5. You have that in your packet. You don't have to look at it right now. But basically what the rule says is that a lawyer, and I'm going to read you the first part here, a lawyer who under the auspices of a program sponsored by a nonprofit organization or court provides short-term limited legal services to a client without expectation by either the lawyer or the client that the lawyer will provide continuing representation in the matter. It's a long sentence. Is not subject to the conflict of interest rules. Is only subject to the conflict of interest rules if the lawyer knows that the representation of the client involves a conflict of interest. And also only if the lawyer knows that another lawyer associated with the firm is disqualified because of conflict of interest. Okay, all right. So, in English, if you are volunteering at a legal clinic, you do not have to do a conflict check for every client that you see at the clinic. However, if you know that you have seen that opposing party to that client, or you learn that when you sit with the client, you would have to remove yourself from the situation. Also, the same applies if you know that one of your colleagues in your firm has seen the opposing party or has another conflict related to that particular issue. You'd have to say, I cannot see that person. But you do not have to do conflict checks. Now, best practice, and in particular, I think this applies for family law issues, best practice, I would say, is to do conflict checks anyways, if it's at all possible. And I know, like when I used to do some pro bono clinics when I lived in Arizona, and I had all my conflicts on my phone, my whole list. So I could actually go to the clinic, and before I sit down with the client, I could check whether I have a conflict or not. And the one time that a conflict situation came up was in a court hearing, and I'm happily going to represent this client when opposing party in the courtroom says, I've come to you for a consultation. Now, she had changed her name, so I didn't have it on my list, and I had to kind of recuse myself, and the judge let me off, obviously let me off the case. But I'm just telling you this can happen, and I think best practice is to do some conflict checks, especially with family law issues. But if you want to do with others too, but you do not have to. In our clinic's legal affairs, we have the client sign an agreement that makes it clear that the attorney that sees them is not their attorney, is not assigned to them as their attorney, and only gives them advice and counsel, and that's it. So that's another good practice to have. Yes?
I was just wondering whether, in your experience, does every provider, whether it be district court or metro court or through legal aid, do that? Because what I have found in my volunteer work, whether it's a veterans clinic, is that they all want your card and your phone number. And they think they can call you, and they think, so I'm just curious whether your experience is that other providers also have them sign a waiver like that?
I really don't know. I know that we do that, but I don't know what other places do. But so that's something to think about. So legally, ethically, you do not have to do the conflict check, but I would recommend for you to think about that. Now, in terms of, and I know we're getting close to time, but in terms of fee agreements, and we touched upon it before, who thinks that for pro bono you do not need a fee agreement? Okay, you're all ahead of us here. So yes, that's true. You do need some sort of an agreement, a fee agreement, pro bono agreement, whatever you want to call it, when you engage a client in in representation, not when you do a clinic or legal fair, but when you see somebody for pro bono, take a case on pro bono for representation. You absolutely need to do that to lay out the scope and the breadth of what you're doing, and to lay out what exactly are you doing, and that you're not charging for your services, but you may include that you charge for certain extra costs if they may come up. That's important to have in there. You also know, I'm sure, that we do allow here in this state to have limited representation. So that's another thing that would be very important to put in your agreement, to make sure what the limited representation consists of, and explain that to the client so that they actually understand that you're not there for their entire case until the children turned 18, but that you may be just there for them for this particular hearing, or 2 hearings, or dealing with the MSA, or I don't know, whatever else the issue may be. Asia.
Okay. And I'm going to do this very quickly since we have about 5 minutes left to do the rest of our presentation. Free process. So clients who are found to be indigent are allowed to get free process in many of the courts. I say many of the courts because some courts have different rules, and education is always happening, but they should be entitled to free process if they are indigent. People might not know that attorneys can actually file for indigency of someone if they know that that client is indigent, or if the client has met income guidelines of a legal aid organization or legal service organization. And so then the client doesn't necessarily have to file that affidavit. The attorney can just go ahead and do it for them. So that document is found in your materials, and it's the attorney certificate supporting indigency and free process. So, if you're at a legal clinic and you are speaking to someone and they're indigent, it's clear, and they need to get free process for something that they're going to file, you can go ahead and do that form with them. And it actually says on this certificate that it does not, the filing of this certificate does not constitute an entry of appearance. So that doesn't mean then that you're representing that client going forward. It just means that you've talked to them and they can get their filing fees waived because you have recognized that they're indigent. There's also an order in there to submit as well. Limited representation. The good thing is that we have limited representation in New Mexico. Not all states have that. I went to a conference, Dina and I went to the Equal Justice Conference and presented on limited representation. And a lot of the attorneys were like, what if you don't have that in your state? And I was like, I don't know. Get the laws changed, I guess. But we do have that in New Mexico. And so it's very helpful to our attorneys, to our volunteers, when they need to limit what they're going to do. They might not do the whole divorce, but they might show up with someone for 1 hearing, or they might write something for the client, and it's very important in that retainer agreement, or whatever you want to call it, to say, this is what I'm doing, this one thing. So you can do a limited entry of appearance, which we've put into your materials. The other thing that you have to do if you're going to do a limited entry is you also have to do a notice of withdrawal once you are done with your part that you said that you were going to do. If you do not do a notice of withdrawal, the judge is going to think that you are still in the case. So they might say, oh, you need to show up for this hearing because you're on the case, right? It says in my system that you did this limited entry of appearance. So do your withdrawal once you're done. And if the judge says, oh, I saw that withdrawal, or, that doesn't mean much to me, you're already entered, let us know, because that's bad. They should not be doing that. So let your legal service organization know, or let us know, mostly if you've taken a case through the volunteer attorney program. I'm going to go into my part about termination,
Sure.
and you can say your piece. So the last piece that I have is about terminating a client consult during a legal fair. So this kind of gets at what Annette was saying. They want your card at the end, they want your number to follow up, and all these things. And I think you also said the other thing, the hard part is sometimes telling them something and then, and something that they need to know, but maybe it's not something nice, or this kind of falls in line with that. Maybe that's all you can do from them. Maybe it's not like, well, call me and then we'll figure this other stuff out, unless that's what you really want to do. I mean, what I would say in a legal fair is break it down into what you can do then and there. As Dina said, sometimes it's very hard to know how to be effective at a legal fair. But if you break it down into smaller steps, that's key. And then you tell them, this is what you're gonna do after this, you know, whatever step that may be. If you don't wanna give them your card or you don't wanna give them your phone number, don't. Because they're gonna think, oh, this person's gonna help me after that. Don't confuse them. It might be hard to say no, but let us know. Let us know, hey, this person's asking what else can be done or whatever. We can direct them to other resources. Unless you want to take that client on, which we are happy about that, mostly if you want to do it pro bono, because then we get to maybe even count those cases for our program. So if at the end of speaking with someone during a consultation, you decide, I want to help this person further, just let us know and we'll make that happen. If you don't, and you feel bad or you're like hesitating about how to proceed, let us know. We can always be the bad guy. We can always be the bad guy. But you do need to make it clear. This is what I have done for you, or this is what I'm going to do for you. It can't be this kind of like weird, like semi, maybe I'll help you, I don't know, kind of thing, you know. And if you want to go check on it and say, all right, I'm done, and then you go check and you say, all right, I don't have a conflict, or I can do something more with this, then let us know. We can call the client and get them all hooked up.
When you take on a client for representation, limited or not limited, whatever, the same rules apply, that you're calling the shots when you feel like you need to get out. So what's important is, if you take on a case through our program, that you let us know. Let us know if there are any problems with clients. It's okay to say, look, this client is like lying to me, or is not following up. We can't work together. It's okay to get out of the case. Obviously, with the court, you have to figure that out and either do a notice of withdrawal, or a motion for withdrawal and an order and whatnot, or a substitution of counsel if there's somebody else. But let us know when you end the case. We also, those of you who work with us already know, we send these obnoxious surveys all the time. So you'll get some of those to fill out. But that really helps us to know what's going on in a case. Now, we do have some, for those of you who are not already signed up with the Volunteer Attorney Program, the VAP, I have some forms if you want to volunteer. I also have some brochures, and I'm going to put those, where do I'm putting those? I'll put those up on that table here, so whoever wants to take some, please do. It includes a malpractice form. If you sign up with the VAP, please also fill out the malpractice form, because all the work that you do through us is covered by New Mexico Legal Aid's malpractice insurance. And no, you do not. No, you're already signed up. But those of you who haven't, I'd appreciate it, and either give it back to me now or send it to us. Thank you so much.
I'm an attorney at Disability Rights New Mexico. My name is Alice Lou McCoy. We do a whole gamut of disability rights issues, and one of the biggest groups of cases that we work on as staff attorneys are Medicaid community benefit appeals. And before I get into what those are, can I get a show of hands of who knows what Medicaid community benefits are in this room? Okay, all right. And how many of you are attorneys? So pretty much everybody? Okay. And you're here today, what are some, can you just throw out some interests? You know, are you just generally looking at taking on any kind of pro bono representation? Are you targeting specific populations? Anybody?
Yeah, a lot of
Specifically for homeless?
Yeah,
Okay,
pro bono cases.
great. And I think what we'll talk about in my session will build on, what's already been discussed. I'm going to approach it as all community benefits appeals. Obviously, some of the community benefits won't apply to individuals who live in public spaces because there'll be, personal care services for people who have homes, people who have personal caregivers come to their homes. So obviously, those kinds of, services aren't going to be for that population. But we're going to talk about the appeals in general and really any of these benefit appeals you can apply to any of these clients. So Disability Rights New Mexico, one of the biggest, as I said, groups of cases that we get, and one of the most popular call-ins that we get at the agency are for these Medicaid appeals. And they can be anybody who is elderly and is getting benefits because, because they need it, or even young minors who have parents who call because their children have developmental disabilities, or people with mental illness. And it's a lot harder to get Medicaid benefits if you're a person with mental illness but no contributing what they call like a physical medical condition. And so those kind of issues can be harder to deal with. But we get the whole gamut of calls for Medicaid services. What I'm going to be talking about today is an administrative hearing. So we're not going to court. We're in front of an administrative law judge. Technically, you don't need an attorney, but it's so vital for attorneys to represent these clients because everything that happens at these administrative hearings is the record. It is the entire record. And no other evidence or information can come in. So even if they appeal that administrative decision to a district court, there's no other information that can come in. So a layperson may not know that there's all this information that needs to go in to complete their record, so that if they are appealing this administrative decision, they have the evidence to be able to win their case. And a lot of times, these administrative hearings, they used to be called fair hearings. I think now in the regulations they've changed it to just administrative hearings because I think some snarky attorneys started calling them fair hearings because they didn't seem fair. The Human Services Department administers the Medicaid program here in New Mexico, and they also run the administrative hearing process. And so a lot of people don't find that fair, and a lot of people don't find necessarily that the administrative law judges are fair. And so I think they've changed the name because of that. And the reason that you should take this case is because they are discrete cases. So you're not on the hook, for, like in guardianship cases, it's a jurisdiction. The judge has continuing jurisdiction of this case for as long as the guardianship is in place. So you could potentially be on the hook unless you get a withdrawal from the judge, permission to withdraw from the case. But in these administrative appeals, you're only, you're not even technically on the hook for any of it. But if you agree to represent the client, then you're really only responsible for that particular appeal in front of that particular administrative law judge for that particular hearing, right? And so if any other issues come up, you're not really on the hook for that ethically. And then later on, if they want to appeal an administrative decision, that's a separate, service agreement you would do with them. And so,
How does the person know that they have the right to have this hearing? What is the notice?
okay, so I'm going to get into that. So at the beginning, I'm not going to talk about exactly what services are covered because there's a huge laundry list, but I have in your handout listed the regulations that will explain in detail what these services are. There's two major umbrellas of services. One is the agency-based, which means you choose an agency and they are the ones who administer your services for you. And the other kind is self-directed. And in self-directed, you choose who your provider is going to be, and you really have to do a lot of management. And at our agency, we really only promote self-direction for people who have a very strong support system. If they themselves some people are very great at, meticulous management of their own services, but some people need help, and if they don't have that help, then self-directed wouldn't necessarily work well for them. But it does provide more flexibility, and there is a broader menu of options in the services, as you'll see when you go over those services in the regulations. So from the very beginning, the way these services work is that once you are deemed to be eligible for Medicaid services, one of the services you get is care coordination. And again, I cited the regulation that talks about care coordination. Do I need to? Yeah. There we go. And what the care coordinator does is come into your home, and they do what is called a comprehensive needs assessment. And what this is supposed to be for is they are supposed to interview you and anybody who you've brought to this interview. So we call them CNAs, comprehensive need assessments. And you can bring in, your client can bring in their personal caregivers, loved ones, any natural supports they may have, so friends and family who may be there to help them out. Anybody who has personal knowledge about what their needs are. So this CNA includes this interview, and then also a review of medical records. You should bring medical records, relevant medical records to this particular interview, to the CNA, and they're supposed to take all of this information into account and figure out what services you are eligible for under the Medicaid Community Benefit Program. In the past, and DRNM has worked diligently to expand this, but in the past it's been, a lot of times these CNAs have been limited to just personal care services, which are caregiver services that come into the home, and how many hours this caregiver gets paid. A lot of times these CNAs are just for that. But if you'll look at these menu of services under these regs, there's a lot. There's physical therapy, there's, in the self-directed you get, even naturotherapy, or if you're a Native American, if you're in that population, then you even get services, cultural services under that too, like shaman services, things like that. So it's really broad, and we have worked with Human Services Department, HSD, to ask those questions about these other services so that we're not limiting, because a lot of people, they don't know what services are available. They're not going on the internet and looking this up. And just so you know, I've listed a few citations. However, if you go on the Human Services Department website, they have all of the regulations listed. They have links to all the current regs. I didn't print out a copy for you guys because it changes, and so a copy you get now may not be relevant next year. They may have, changed certain definitions or deadlines, et cetera. So you really do, for each case, have to look at the regulation to see where you're at and what rules are in place for that particular case. And I'll get to how an easier way you can do that too. So on the website, if you're curious, they're all listed, and the community services benefit is one link, and then administrative hearings is another link on that website. So one issue that we've run into is that clients don't necessarily know what services are available. So in order to do that, they would have to look at these regs that I've cited before to know what they are. That's a front-end thing. That's nothing you can do anything about. And so another issue that they run into are denials, right? A lot of times because they didn't know about the service, they didn't ask for the service, and they don't get a specific denial for it. And we've run into issues where HSD has said, well, we didn't technically deny anything. Well, they didn't know, and if they didn't know and they didn't get the service, then they were denied that service if they needed it in the first place and they didn't know it was something they could get. And so we've run into fights on that. What you might run into is a client will come to you and say, I didn't know that this was a service. What do I do? I don't have a written denial. And a lot of times what we recommend they do, because we get so many of these cases that we can't really take them on the front end like that, we ask them to try to generate a written denial. And so the way you would say this is, you know, I just got notice, right? You would tell the client to write a letter to their care coordinator. I just got notice that this was a service I was supposed to be able to get. I need this service. Please respond by X date or whatever. So you're generating that denial. And the reason the denial is so important is because all of the administrative and the appeal timelines start from the denial date. And so you create a denial date by generating a written denial. A lot of times you get very informal conversations between the care coordinator and the client, where the care coordinator is on the phone with the client and they say, you know, something flippant like, we won't do that, or we've never done that, or whatever, you know. That's not good enough. And so what you'll have to do is ask your client, or if you are willing to do it and would like to, write a letter and memorialize that, you know, write those things down and put them and create a record. Because without the denial date, there's no real way to start the timelines for the appeal.
Can I ask you really quick?
Yes, please.
In today's world, why would they even give you verbal anymore? Why aren't they creating their own record of denial?
That's a good question. A lot of times, you know, they don't really want to. Some of these care coordinators aren't that well trained. You know, maybe they haven't been doing it a while. It's not really in their best interest to put things in writing, because the fewer things that kind of go under the radar, the fewer services they have to provide. And so we've had to work closely with Human Services Department to ask the MCOs, managing care organizations, which are the insurance companies, to when they send their care coordinators out, to actually ask them these questions and to say, do you need this service? Do you need this service? And so we did work with them to create a survey that would require them to ask these questions. Whether or not they're being used in the field, you know, we've yet to see. So it's a relatively new, within the last year, agreement that we've made.
So I guess a form would be wonderful.
Yeah, so we created this form, again, whether or not they're using it. Okay? And then each MCO, of course, can adapt this suggested form from HSD to however they want to do it, right? And so they usually have computer programs. A lot of times they're pretty high tech now. These care coordinators, they go into the home, they've got like an iPad or something, and they have this program. And a huge issue we've run into is they have all these different questions, but the questions sort of run on a decision tree a little bit, like yes, no. And so if the care coordinator doesn't answer correctly for one of the questions, then a whole bunch of questions doesn't get asked, you know. So, you know, like a whole cascade. And so then they could miss it that way too. So we've run into issues with that as well. Yes?
So, do the clients have to specifically request each service that they want, or are they just given them by the care coordinators?
Our legal position is that they don't have to request anything, that these services are available to them because they've already been determined to be eligible for these services. So there's already a preliminary determination that says I'm eligible for these, you know, this group of services, the community benefit services. It's up to the care coordinator to find which services and how much of each service, in what amount, in what duration, the scope, all of that. That's the care coordinator's job. That is not the client's job to do that. They've tried to shirk that responsibility by saying, well, you know, we didn't technically deny it. Well, you know, they didn't know about it. And it's your responsibility you're the one who knows about it, you have to do that. But again, in practice, you don't necessarily see that. And so when you get this case and you get a client that comes to you and says, I didn't know about it, then you have to start creating that record of, you know, you have to get very specific information. When did the care coordinator come to your home? How long was the interview? What questions did they ask you? You know, it's based off their memory, so it's not perfect. And a lot of times, you know, I'll see, so the care coordinators come in every year. So every year that you have community benefits, you get a CNA. And it's redone every single year. And a lot of times there'll be huge changes in circumstances, and we'll see an assessment that looks exactly the same as last year's, because what the care coordinator has done is just, you know, submitted again last year's I haven't changed a thing, not even in the narrative. So a lot of times, the MCOs have tried to cover their paths or their tracks by taking a lot of the narrative parts out and doing those yes or no questions and multiple choice questions with the cascading decision trees and all that to try to cover their tracks. But there still are some narrative sections. And when you see a big red flag to me is I want to see assessments from prior years. And then sometimes I get repeating clients who come year after year. And then when I see that all of these words are the exact same words that you said the year before, even though there are huge changes in circumstances. For example, their main caregiver, who was a family member, passed away. If that's not even noted on the assessment, obviously that's a huge issue. But this is a very common problem. And a lot of Medicaid benefits are often the one thing that keeps a person safe and healthy in the community. Otherwise, they would be institutionalized, hospitalized, et cetera. And so without these services, their lives drastically change. And so it's very important that they get all this done right, but the system works against them. There's no real direction on how to do it. And it's not until you get down into the weeds where you realize, I don't have anything, what do I do? And you're asking for help, that you might actually start looking at, what was I entitled to? Because you want to trust the system. When someone comes in, you want to trust that they're going to do what they're supposed to do, and they don't always.
Does the requesting party get a copy of this assessment?
Yes. So what happens, wait, can you ask the question again before?
The person requesting the care, get a copy of the assessment?
Okay, that's a good question. Yes and no. Not generally, but they do if they appeal. Okay, and so again, the timelines get triggered. You have the reason I'm hesitating is because there's different regulations, and we've also had litigation over this on what the timelines are, and they're conflicting. But when you get a written denial, the reason it's important is they tell you what the deadline is. They tell you what the deadline is to appeal, and the first level of appeal is the internal appeal. And usually, DRNM doesn't get involved in that part. We just tell them, look, you or your caregiver or somebody helping you, if you can't do it yourself, needs to turn in a written appeal, right? Just saying, I don't agree with this assessment. I don't agree with this determination. I want to appeal. And then they do an internal appeal, which almost always comes out the same. And then they come to us, because then after that they have 30 days. So they usually have 90 days to request that initial appeal, and then they have 30 days after that to request a fair hearing. So the administrative hearing, that's when we get involved, because that's where things get tricky. We're in front of an administrative law judge. Yes?
Can I ask, are there always internal appeals?
Yes.
Always?
Yes.
Okay.
Yes. For these specific Medicaid community benefit appeals, every MCO that I've worked with has internal appeal process. I don't want to be cynical, but it's a lot, as much red tape as possible. And it's it's in the regs. It's in the regs that they can do an internal appeal and should. So they do. Some, like Presbyterian, they have 2 levels of internal appeal. So you have to do initial internal appeal, then you have to have a secondary reviewer appeal, and then you get to go to your administrative hearing, whatever. And so the reason why the deadlines are kind of tricky is because in one section of the regulations, it says you get 90 days to request your fair hearing from the date of denial, but really you get 90 days for that internal appeal, and then an additional 30 days to request that fair hearing. What the problem we came into was we had a client who requested the internal appeal right away, but then missed that 30-day deadline afterward, but was still within the greater 90-day window. And so we had to get into a big procedural fight about that. But really pay attention. The client needs to pay attention to those deadlines on their denials. If they don't get a written denial and they have to generate their own written denial, then I think there's a hard and fast rule, within that 90 days after you've generated your written denial. If you say, if you haven't responded to my request for this service by X date, then I will take this as a denial. and then from that date, they have 90 days to request that fair hearing, or I'm going to call it administrative hearing. I do in all my pleadings. And so when they request an administrative pleading, they have to, hearing, they have to do that in writing as well. So everything needs to be in writing. And that's another thing that's really hard for clients. They're used to the care coordinator coming to their home. They're used to them talking on the phone with them. They're used to all this verbal communication. They're not used to any written communication. A lot of our clients, can't write for whatever reason, and would need somebody to do a written communication for them. But everything does need to be in writing to create that record. It doesn't necessarily have to be, but there's no way to trigger these timelines and to trigger your right for a hearing unless you can show that there's been a denial. So another issue that comes up is, another challenge that comes up is a lot of times the clients have problems getting access to providers, and that can look like, I live in a small community. There isn't a provider that provides this, and so in that case, there needs to be work with the care coordinator, and then whoever is above the care coordinator to look outside the community and see if there are services, long distance that they could, even all the way to the coasts or whatever. If it's something very specific that is specialized that just isn't being offered, they still need to offer it, and they need to provide transportation for that as well. Another problem with access to providers is sometimes we have clients who, because of their mental illness or their disability, they may alienate some providers, or sometimes we have clients that, because of their disability, have made verbal threats to their providers, and their providers are allowed to, cut off service. That's something they can do, but then they still have to get the service from somewhere. And so that can sometimes be an issue with access to providers as well. And part of working with a population, with disabilities, with mental illness, or who live in public spaces, is that often you might run into that kind of issue, and that is just something that we have to deal with. The bottom line is these are individuals who need specific services, and there needs to be problem solving around how to get that to them, whatever that may look like. Okay, so now we get to the internal appeal. Do we have any questions so far over what I've covered? Okay. So once you get to the appeal, it's a very prescribed process. The procedure is under an NMAC. I'm not going to read it out to you, but it's cited right there. So yeah, I've cited the internal appeal process, which they have to follow, the MCOs have to follow, and then the administrative hearing, which will be all the rules that us lawyers are super interested in. And so this is what we need to really pay attention to. This will tell us, how the hearing itself is going to go, what the evidence needs to look like, and I'll get into that in the next section. But these are all the rules. So before, a lot of times we get clients that come to us and they've asked for the administrative hearing, or if they haven't, we tell them do it, ask for that administrative hearing, and they get scheduled. And the first thing that happens, or that should happen, is that after they ask for the hearing, they will get a acknowledgement that they asked for the hearing. So they should always have a copy of that. If they haven't gotten one, that's a problem. And more importantly, they should get a summary of evidence. The summary of evidence needs to be provided to them within a certain amount of time, and it's also in the regs. And the summary of evidence is very important. It includes everything. So you had asked earlier, I'd gotten a question of whether or not they get a copy of this assessment. They do in the summary of evidence. So in the summary of evidence, it's a timeline that's created by the MCO, usually. It's almost always there's that. There's the assessment itself, which includes the tool that they use to ask all the questions, so the survey questions and the answers to those questions, and then what's called an allocation tool. If it's, for example, if it's personal care services hours, how many hours your caregiver gets, then there's a tool usually where they have specific hours that they're assigning for each service, and what's covered under there. So like grooming or bowel and bladder, and how many hours are assigned for each of those services. This is really important for people who are, and vast majority of our cases are caregiver hours cases, because these are so important. This is what keeps our clients in the community and keeps them safe and healthy, and they don't have to go to a nursing home or a hospital or whatever if they can get adequate services. The tool has categories, severe, moderate, whatever, and then they have these what looks like hours caps for each category. There is no legal basis for these categories. This is a general rule, so that it's not a rule, it's a suggestion, I guess, for MCOs, because if the care coordinator doesn't really know how to do this, I'm not really sure why it's there, other than there's got to be some kind of baseline for us to go off of. But there's no legal basis for these. And so what we do when we go into these cases is we ask them very detailed questions about what their needs really are, how long it really takes to get each of these services done and get what they need taken care of. And we provide that information at the hearing. But you should see that allocation tool if they're getting hours services for anything. You'll also get you should also get a current copy of the regulations that are relevant to that particular hearing. So if they are an agency-based, or actually it's the same regulation, so you should get the current regulation of what services are available under the regs, and you should also get the current regulation of the appeal, and it should all be in there. And the client usually doesn't see any of that until they get the appeal and they get this huge packet, if they even read it, and many times it's really overwhelming for them to try to dig through all of that, because the regs are hard to read. They're like badly written statutes almost. They're just really hard to understand, and they refer back and forth to other sections, and they're thick. I mean, the summary of evidence is usually a couple inches thick, and so it's up to the attorney to slog through it and make sure that everything's in place. What should also be in the summary of evidence is anything the client or their representative has submitted on their behalf related to this hearing. So if they've requested a written appeal, a copy of that request should be, if they've requested an administrative appeal, a copy of that written request should be in the summary of evidence. So anything that they've submitted. If they've submitted doctors' or medical records, when they've asked for the appeal to support their appeal, then that should all be in there. And if it's not in there, it is up to the client and us to submit that in our own summary of evidence. Questions so far about this? Okay. So in the summary of in our summary of evidence, what we always look for is we want to make sure that we prove up our case. The burden is on the MCO to show that their assessment is correct. It doesn't always work that way. The administrative law judges don't always require more than for the MCOs to just submit their summary of evidence and then read off their summary of evidence. So really it's up to us to make sure that the record is very, very comprehensive, because if they are appealing to district court and because the administrative decision doesn't come out in their favor, and they don't have that evidence in there, at the district court level, the burden is on the client. So if they don't have what they need, that's it for them. And that's another reason why it is so enormously important for attorneys to get involved at the administrative appeal level. Because I do often, get asked, well, is it that important? They don't require attorneys. The rules of evidence don't even apply. It's very open. Usually the administrative law judges will accept almost any kind of documentary evidence or testimony. You don't need to prove up anything. You just, have your witnesses say their piece. You submit the documents you need to submit. The facts are just kind of thrown in. There's no need to follow any kind of, and it's the reason they do that is because a lot of these appeals are not done by attorneys, and they want to make sure that they get all the information that they need. when attorneys do get involved, things get a little stickier, right? The MCOs bring out their own attorneys, and they start doing things that look a lot more like litigation. So when you bring your witnesses up, you'll get cross-examination. The great thing is when you bring your witnesses up, they can speak in narrative form, so you don't have to, back and forth answer, a question-answer format. You can just let them say their piece. A problem is if they try to read, sometimes you'll get in trouble for, are you reading? Because a lot of my clients and witnesses sometimes will get really nervous, I'll say, look, you can make some notes, and if they accuse you of reading, just say, I did make some notes for myself, and usually it's okay if you say, I'm nervous and I made some notes, and I just want to make sure I'm remembering this correctly. I'm not saying it's okay to coach, I'm just saying it's really important when you do your witness prep that you make sure they say all the information that they need to say at these hearings. Most of the time these hearings are done over the phone. I think the whole system prefers it to be that way because it's just more convenient. A lot of times the administrative law judges are just only in Santa Fe, and we're talking about appeals all over the state of New Mexico. I go to my client and I call in for them, and I bring my own speakerphone to make sure it's, and I make sure that there's a working landline. Sometimes it's hard, I'm out in the reservation or whatever. And I'm there with them, and it helps them stay confident and feel less nervous, because a lot of these people have never testified before, and even though we're not in a courtroom, it's still very nerve-wracking for these clients and their family members or whoever they have as witnesses. And so it's just really helpful for me to be there with them, and it helps with the prep and everything like that too. Sometimes I do request a live hearing. I do that when my client is a person who cannot speak for herself, and I would still like for her to be a presence in the hearing. And so I'll ask for a live hearing, and we'll bring the client so that they can feel like they're part of the hearing and feel acknowledged by the administrative law judge, by the MCO, by the MCO's attorney, by their witnesses, and see their conditions. Sometimes, a picture, is worth 1,000 words. So bringing the client can be very beneficial to your case if you feel like, that can provide its own evidence, just their presence. A lot of times you can explain and describe a lot of these conditions that your client might have, but unless you really see it, you don't really get it. So sometimes I do ask for the face-to-face hearing. I've never had an MCO ask for a face-to-face hearing. That's only been on our end. So let's talk about what kind of witnesses we want to bring to the table. By far the most powerful witness and the most important witness, if we can get it, is live testimony from a medical provider. Either the primary care physician, or if they have specialists for very specific conditions. Evidence, spoken evidence, and making them available for cross-examination is very powerful evidence. So if I can, I try to line up at least one medical provider to give the evidence I need for them to give, and also be available for cross-examination. I do some prep. It's really hard to nail down these providers. They're very busy. They have lots of appointments, so you have to give them a lot of advance notice. And then you have to schedule your prep with them in a lot of advance notice. I mean, you're basically an appointment that they could be seeing a patient. And so it's very important that you respect their time. A lot of times they'll try to see you, or they'll try to talk to you between patients. That can get kind of rough because they're very rushed and it's hard to get them to focus. So what I try to do is, before I do the prep, I send them a lot of not too much information because they won't look at it, but like a quick outline of what we're looking for, and then they can prep. Or at least they can pull up the outline and have something to look at while they do these prep sessions with you over the phone. And so they'll call in. And another great thing you can do for your medical providers, and that increases the chance of them actually testifying at the hearing, is you can set a time. If you know your hearing is scheduled at 1:00 p.m. and the doctor only has an opening at 2:00, then you can request ahead of time that the administrative law judge reserve the 2:00 slot. So wherever we are in the hearing, everything gets put on hold. The doctor calls in at 2:00 and does their testimony. They get crossed then, and then they can get off the call and they're done. You know, obviously if you want to use them as a rebuttal witness, that can get kind of tricky. They may have to call back, whatever. But if they really do need to have a specific time slot, you can ask for that. And I've never had an administrative law judge say no to that. They usually say, okay, we can do that. So that's another great tip for getting those medical providers lined up. If you can't get live testimony from a medical provider, another thing that can be really helpful are letters. So I always do both. I do letters, and then I do testimony, and then part of the testimony can be them reading parts of their letters and you know, elaborating on those letters. So I try to get multiple medical providers, if possible, to corroborate the evidence. And a lot of times the doctors are really busy and they're not sure what you're looking for, so you can send them either, you know, like an outline of the kinds of information you're looking for. Sometimes I might even send them a sample letter, and they love it, so they just use it and they sign it. But you know, the sample letter is just to give them an idea of what they should be giving you. And I encourage the doctors always, always, always to make it their own, to add any information that I might have missed, you know, from looking at the documents. I'm not a medical professional, you know, there is information that they can give us that could be really helpful, but you have to ask the right questions. And you know, some of the right questions are, if you don't know much about the diagnosis, then you can ask them to elaborate about the diagnosis, how it affects the person's daily life, how you know, it affects the person's long-time prognosis and health, whether or not a really important fact is whether or not this diagnosis will progress and worsen. What we sometimes see is we'll have a progressive condition like MS, which never gets better, just gets worse and worse and worse. But somehow the MCOs want to cut hours every year, even though there's no other change in circumstances other than they're just getting worse. And so we ask that the doctors emphasize the progressive nature of the condition. So information like that can be very helpful for your evidence. Other witnesses that can be helpful, but you have to be a little careful. Family members, close friends, they tend to want to ramble and run long, and so you have to keep them focused. A lot of times, the ALJ may get frustrated with this, you know, sort of rambling narrative, and they're trying to get their frustrations out because they've dealt with these issues for years probably, and they're just so mad. Sometimes I have to go in and do the question and answer with them to keep them focused. Otherwise, people stop listening, or worst case scenario is the ALJ cuts them off and says, let's get to the point here, like where are we going with this? And they expect the attorney to do that for them because we're there, and so we should keep the witness focused. But they can provide very important information. One problem is with these benefits, the MCOs are not required to cover benefits that are provided by natural supports. And natural supports are defined in the regs, but generally they are people who are close to your clients, whether they're family members or friends or church members or whoever, who can provide consistent care, who can provide consistent services that these benefits would normally cover. And the MCOs will try their very darndest to find as many natural supports as they can to say, oh, these natural supports are providing these specific services, we don't need to provide them. And so our job is to go in and find out really how consistent are these services. Is it like if they have time once a month, they might come in and do that? If so, that's not a natural support. That's not a natural support. A natural support is somebody who would be there like it's a job, like they're getting paid. And sometimes what we have to show is with these providers who are actually getting paid, we have to show that they would have to get another job to support themselves if they were not getting paid by the MCO. So that gets a little tricky, right? So we have to show, look, they are a paid service provider. They're not a natural support. They don't have just the time to give and donate to this client, they actually do have to get paid for their services. Otherwise, they would have to get in their job, and then this person would not have a service provider, and this person would be without the service. And so, you have to show that through testimony or whatever evidence you can provide. I had a client who was depending on, she was completely bedbound and nonverbal, and her family had taken care of her entire life, but her entire family depended on this income from Medicaid to be able to do that for her. And when her father passed away, he was her primary caregiver, they had to ask other family members to pitch in, but because Medicaid wasn't paying out enough, these other family members, one of them just quit completely. They just had to because they had their own families to support, and they had to get another job, so they just couldn't do it. And then the family member that was going full-time anyway, she was suffering her own financial distress because they weren't getting paid enough money. And she did end up passing away because she did not get, I say because she did not get the right services. They say because her condition worsened enough. But the consequences are dire. And we have to do our best to show, and we were in the middle of this appeal when she did pass away. And I think one of our strongest pieces of evidence was bringing in that caregiver who had quit and said, look, I had to quit, I had to get this other job, I had to support my family, and now she doesn't get all of these services because I couldn't be there to do it for her. So there are lots of ins and outs as you look at the regulations. If you ever do get one of these cases and you do take it on, and please take it on. We get so many, we can't actually do them all. We are more than happy, DRNM is, to provide guidance and to provide advice, because once you get into the weeds of these regs, you'll see, the way they define services may be unclear, and they may define it one way, we may understand it another way. So just please feel free to call us. DRNM is actually working on a pro se self-help manual for these hearings because they are so common and they are so important. And we hope that this will be a really important resource as well for pro bono attorneys to use. And in fact, I think it will probably be more useful for you guys than it would be for just a lay person, because it will be a pretty technical manual with sample forms and questions and witness outlines and things like that, which can get very overwhelming. And so we'll have, sort of general overview, which is what most people will just look at, and then we'll have really nuts and bolts, and we're working on that right now. But in the meantime, please, contact us if you have any questions. We're more than happy to help, and we really do want more people to take these cases on, because we turn people away all the time because we just don't have the capacity to take these cases. One of the biggest problems is these cases come back every year. So they get a new CNA every year, and they're either still not getting enough hours or they're getting fewer hours. And one of the saddest circumstances we see is it's very, very difficult to show after your, I'm saying hours, but it's really all services. But it's really difficult to show once you've had services, once you don't use a service, right? Or once you don't use the amount of service that you were originally given, to next year and say, I need it, or I need more. And so what happens a lot of times is they may not get that service. They either didn't know that they were supposed to get it, or they didn't know how to do the appeal, or they just said, okay, well, too bad, for this year. And then next year they'll want it, but then it's really, really hard to show at that point that it's medically necessary. And so sometimes I'll see, and I'm using our caregiver hours as an example because it's such a rampant example for us. We'll see hours getting reduced every year, and it's hard to get them ramped back up. And they don't come to us until maybe like the third reduction, and by that point, maybe they had 60 hours and now they're at 34 and panicking, and they come to us, and it's really difficult for us to kind of push it back up. And I'm working on a case that they originally had 56. They didn't come to us until they were at 29, and we're back up to 38, but we're still working. And she is much more severe. She has MS. This client condition is much more severe than it was, a few years ago when they had 56 hours. I think we're back up to 54 now. I'm sorry, what's that?
How do we get in contact with you?
Okay, good question. So, Disability Rights New Mexico, the way you contact us is on our website. You have our phone number. We have an intake. For all clients, but for attorneys like you guys, you can ask for any of the staff attorneys and just say that you came to the CLE, that I was, that I presented at the CLE, and really any of us will talk to you. I'm more than happy to talk to you, but any of the staff attorneys are happy to talk to you about this, or they may refer you to me. That's fine too. You can ask me for me directly. But if you say specifically, I went to the CLE, I'm an attorney, then I will definitely talk to you. I get a lot of calls from, lots of like lay people as well, and I can't take all of those calls. But if you do specify I was at the CLE, then I promise I'll talk to you. Baby or no baby. Baby may be in the background crying, but I'll still talk to you. I'm on maternity leave. And I am working from home, so really as soon as you get a case and you have a question, please call us if you have any questions. Yeah, okay. So another thing that you get to do as an attorney is a lot of times the administrative law judge will ask for opening statements and closing briefs. They almost never ask for closing briefs if it's a lay person, but sometimes they will for attorneys, especially if there's a legal question. And for opening statements, I like to reserve my opening statement for my, at the beginning of my presentation of evidence, at the beginning of my case. That way it doesn't get chopped up, and it's kind of like a great introduction overview. Usually what happens with the MCO is because they have the burden of proof, they get to go first, so they'll do their opening statement, or they may dispense with the opening statement and just start reading their summary of evidence. Some administrative law judges will cut them off and say, no, I don't want to hear that. I have it right in front of me. I don't need you to read it to me. And some will allow them to just read and read and read. And so you may be there for an hour before it's time for you to present your own evidence. So I like to reserve mine. You can do whatever you want. So I just ask for that at the beginning. I ask the judge, and they always say that's fine. I do my opening statement. I bring in my witnesses. One thing you do want to pay close attention to is there are some issues that you can bring to the judge's attention, whether or not it's important to them isn't as important as it being in the record for appeal if the client does decide to appeal. So usually the testimony given by the MCO's witnesses are a secondary reviewer who has never met the client. And so they're making a determination about what services they need based on the reports that the care coordinator gave them, which may or may not be accurate. And so you can kind of build this hearsay upon hearsay, argument saying, well, how could they possibly know this is, if you're weighing the evidence, judge, think about their evidence, which is a secondary reviewer who's never met our client, who says they have expertise doling out these services, but they could not know the particular circumstances of our client versus our witnesses who have intimate knowledge of our client's needs and their condition, et cetera. So, you want to point that out, and you do it both in the cross-examination and in your own statements, whether it's opening statement or I like to do it in my closing. So sometimes you'll run into, I'm not going to get into the legal issues because we'll be here for another 5 hours, but so there are some legal issues that you may find in the regs that you want to raise. And if you do, then a lot of times the administrative law judge will ask for closing briefs so that you can do legal argument, written legal argument. Thank you. I always ask to do a closing brief even if there isn't a legal issue. And the reason I do that is this testimony can get kind of scattershot, and I'm not confident that there's going to be a really good summary. And there might be issues that come up during the hearing that I didn't anticipate. And so what I always do is I ask for a closing brief. I've almost always gotten one. A lot of times the administrative law judge wants one because there's so much information coming in, it's hard to get a real clear picture of what's going on. And in your closing brief, you can do a really clear summary of your evidence and of why your case is persuasive. You can highlight the important evidence. You can highlight the weaknesses in theirs and make your arguments in the closing brief. So I always ask for one. It's really important that the judge gets that clear picture, especially if you're looking at really nitpicky things. I'm going back again to caregiver hours. If in those cases, it gets down to, how much time does it take to clip your fingernails or whatever, and that gets included. And so you want to capture every minute, because every minute adds to your total hour request that you're making. So you want to really outline all of that. You don't want to ask the administrative law judge to go back, especially if it's been a long hearing, and listen to a 3-hour-long recording. They may or may not listen to it. You want to make it as easy as possible. And if you do that in the closing brief, it's right in front of them. You can basically make a chart even for them. I don't do a chart, but I do paragraphs and sections so that, I add up all the hours for them. I do all the sections. It makes it a lot easier for them. So these different services have categories, and so if you lay it all out in an organized way in your written closing, it's so much easier than to ask the administrative law judge to go back through this recording, which a lot of times is garbled, and you don't always hear everything, to ask them to do that for you. Okay, so really fast, I wanted to touch on, I'm not going to talk about the motions to dismiss because this is a rare occurrence, but I am going to talk about the administrative appeal, or the appeal of the administrative decision. So after you get the decision, you get 30 days to appeal to district court. This is, again, like a totally new case, so you can decide whether or not you want to represent the client. I almost always do, because I built this record for a reason. And so if the client wants to, they may not want to, we do what they want to do. And if the client wants to appeal to district court and we have the capacity, we take on that appeal. And the great benefit to that is we've done all the legwork, we know what the evidence is. Another great reason for you to do a closing brief is that part of the record that goes to district court is a transcript of the hearing, but you don't have a court reporter at the hearing. You just have somebody over at HSD listening to a garbled recording, typing out what they think you said. And so a lot of times it's not accurate, it's not clear. And so it's very beneficial to have the attorney that worked on the case do the appeal, because they know what was actually said. And it's also really important to have this closing brief because you've made a final statement about what was said. So if something was garbled, I've already run into this in appeals that I've done to the district court, where I see what's happened or how they've transcribed it, it's incorrect, but because I had written a closing brief, it's in the evidence, it's in the record. So the evidence that I needed, the testimony that I needed was summarized in my closing brief. And that counts, it's part of the record. So I can refer to that, I can cite that when I do my statement of issues to the district court. So I'm going to wrap up. Any questions? I just wanted to save 1 minute for questions. Yes?
How long does it take you to do one of these cases, or your
You mean
attorneys?
just from like start to finish?
Yeah.
So depending on when the hearing gets scheduled, depending on when they actually ask for the hearing and all of that, we don't take, and because of that reason, we don't take the cases until they've already asked for the appeal, they've already asked for the hearing, and they've gotten an acknowledgement of the hearing, they've gotten a hearing date. And that's when we take the cases usually. We've taken them earlier before, and in some circumstances, we'll even take them at the internal appeal level and help them at that level, especially if there's a secondary levels to that internal appeal, because a secondary reviewer, it's almost like a mini administrative hearing, and they have people there asking questions, giving testimony, things like that, but within the MCO's system. So it usually, I want to say like 90 days is a good estimate, but I've had cases that are years long just because we've had motions dismissed, we had to fight that, then we went to district court to fight that, then we went back, and then we had multiple administrative hearings because by that time we had another assessment, which is also not a good assessment, and we've tried to combine the two. So, but that's not going to happen to you. That's a rare occurrence. Usually what happens is you get that discrete assessment. If you move things along, and especially if you encourage your client to move things along, then you can get it done before the next assessment, and then it's a strong position for them to be in if you've won an appeal to go back and when they try to reduce the hours again, or to go back to the old hours and you've gotten more hours.
Hours to collect your evidence.
I'm sorry, what was that?
Hours to do your summary of evidence.
Oh, To do my summary of evidence? Oh, that's a really good question. And I should be able to answer that because we have to bill time actually at our agency. But because for our grants. It just depends on the case. You know, some cases have a lot. You know, if it's a really complicated diagnosis, then I'm talking to a lot of different providers and I'm interviewing them all and I'm asking for, and I'm prepping them and all of that. And if it's a pretty clear-cut case where they just have one medical provider, then I'm only talking to that one person. It depends on how many natural supports they have. It depends on how many people have the necessary information. So it really depends on the case. There's no good way to answer that question. Anybody else?